Hello everyone, I'm Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's video presentation is the scope of Section 2 Clause 2 under Arbitration and Conciliation Act. So Section 2 Clause 2 talks about Section 2 Clause 2 states that whether this part shall apply where the place of arbitration is in India. The Arbitration and Conciliation Act of 2015 provides that in Section 2 Clause 2 the following proviso shall be inserted. Provided that the subject to an agreement to the contrary, the provisions of Sections 9, 27 and Clause A of subsection 1 and subsection 3 of Section 37 shall also apply to international commercial arbitration, even if the place of arbitration is outside India. Section 9 talks about interim measures by the court. Further, Section 27 talks about court assistance in taking evidence. And Section 37, Clause 1, Subclause A talks about granting or refusing to grant any measure under Section 9. So, whether Section 2 Clause 2 will be applicable to foreign seated arbitration or not, the position before the case of Bhatia International case, the position before this case was in Dominant Offset Private Limited versus Adamowski AS. The Delhi High Court declared the scope of Section 2 Clause 2 as being wide enough to include the arbitration taking place outside India. Secondly, the Calcutta High Court in the case of East Coast Shipping Company Limited versus MJ Scrap Private Limited held that the Section 2 Clause 2 of the Arbitration Act restricts the applicability of Part 1 of the Act to arbitrations in India. The third case was the division bench of the Delhi High Court in Marriott International versus Ansal Hotels restricted the applicability of Part 1 to only arbitrations held in India. It was further observed that the court has no jurisdiction to entertain such a petition for grant of interim measures being held in the relation to an arbitration outside of India. So the position as laid down in Bhatia International versus bulk trading, the Supreme Court in its 3-judge bench held that an application for interim measures under Section 9 can be made to a court in India even where the seat of ICA was outside India, unless the provisions of Part 1 have been excluded by an agreement between the parties either expressly or by implication. In this case, the contract contained an arbitration clause providing for arbitration as per the rules of ICC. A sole arbitrator was appointed and venue was decided to be in Paris. The respondent filed an application under Section 9 in the District Court of Indore for obtaining an order of injunction restraining the appellant from transferring its business assets and the properties located in India. The appellant opposed the application on the ground of maintainability by contending that Part 1, which contains Section 9, would apply to arbitrations conducted in India. Madhya Pradesh High Court also rejected the petition filed by the appellant. Then appellant filed an SLP before the Supreme Court. The issue was whether an Indian court can grant interim relief under Section 9 of the Arbitration and Conciliation Act in cases where international commercial arbitration is held outside India. Supreme Court held that Part 1 grants power to the courts to order interim measures to even international commercial arbitrations taking place outside of India, except if the parties by agreement had expressly or impliedly excluded all or any of its provisions. The implication of the decision in the Bhatia International case was that all the proceedings in Part 1, including the provisions under Section 34, Clause 2, Subclause B, Subclause 2, that is setting aside of foreign arbitral award, award on the ground of conflict with public policy in India, would now be applicable to foreign seated international commercial arbitrations only. And so this was the issue of whether the scope of Section 2, Clause 2 of the Arbitration and Conciliation Act, whether the foreign arbitrations are can be held or not. So I hope I was able to explain to you all. Thank you.